checked in. So as I call your name, if you could confirm that if there is a name on the screen for you, if you could confirm that's correct. And let me know who you're representing here today, whether you're the applicant, owner, or adjacent property owner, or some other party. So I'll start with what looks like Jen Quackenbush. And if you could unmute for me. No. So it's usually down the bottom left of the screen. There we go.
Hear me now?
All right. Yes, I can.
It's Jen Quackenbush.
Okay.
I am one of the owners.
All right. Welcome.
Thanks.
I see we have Brian Graham. Is that right? Doesn't look like Mr. Graham is connected to audio. Just give me one moment here, guys. Mr. Graham, can you hear me at all? Okay. I will come back to Mr. Graham. We have Lou, is it Cohus? And you'll need to unmute.
Yes. Lou Coas.
Cohus, okay.
Yes.
All right.
Thank you.
And Mr. Cohus, you're an adjacent property owner, that's correct?
Yes, sir.
Okay. Welcome. And then
Thank you.
is this Quackett Culinary Arts? Could you give me your full name?
True Quackenbush.
Got it.
Yeah, I'm one of the property owners. Sorry, it's school Zoom account.
Not a problem at all. All right, welcome. Then I see we also have Kate Meehan from our zoning department at the city. Welcome, Kate.
Hello, thank you.
Hi.
All right, so looks like Mr. Graham has signed off. Maybe I assume he's going to try and get back on. So if he does rejoin, I'll attempt to get him connected. But unless the owners are waiting for anyone else to join us, I'm going to go ahead and read through our hearing script and the procedure for the hearing.
I think you can continue.
Okay, great.
We'll see if anybody joins us, but
does anyone here know who Mr. Graham is or why he's here?
yeah, he's actually 2 houses up from here. Was here in support of the fence.
Okay, great. Well, yeah.
It's one of the letter writers.
Looks like he's trying to come back in now, so I will go ahead, see if we can get him connected to audio. There we go. Mr. Graham, can you hear us? If so, if you could unmute. Mr. Graham, you there? Okay. I will again give him some time to try and fix that, but let's go ahead and start by reading through the hearing script, which will cover the procedure for the hearing. Mr. Graham, if you can hear us, could you wave your hand or say unmute? There we go.
I logged back out, logged in, so I hear you, and I finally figured out how to unmute. Sorry about that.
Okay, no problem. Thanks for joining us. I assume your name is Brian Graham.
Yes, it is.
And you are a neighboring property owner, correct?
Yes, I am.
Okay, fantastic. Thanks for being here. I'm just about to read through our hearing script, which will cover the procedure for the hearing. So this is the November 8th, 2023 session of the zoning hearing examiner docket. The purpose of this hearing, I'm sorry, the case before us today is case number ZH20230160. That's 1299 Maryland Drive. The purpose of this hearing is to allow applicants and any potential opposing parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any potential opposing party wishes to offer must be presented at this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent, or the owner will first present the applicant's case. Anyone from the public will then have an opportunity to speak after the applicant has presented its case. I'll hear from our zoning plans examiner, Kate Meehan, to provide any testimony in addition to her staff report. In the event that any party testifies or offers argument in opposition to this application, the applicant will have an opportunity to rebut that testimony and or argument that was offered in opposition. And then finally, the applicant will have an opportunity to make any closing statements. Excuse me. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or to make any comments. I may also refuse to consider hearsay testimony, which is generally evidence you want to introduce that consists of statements made by someone who's not present at this hearing. That is discretionary. In the event of any technical difficulties, as we've already seen here a little bit, I'll do my best to troubleshoot those on the fly, but to the extent there's some defect that prevents us from me fully going forward with this hearing, I may continue or postpone the hearing at my discretion. Okay, last thing I need to do is just swear in all of our witnesses. So if you intend on providing any testimony here today, making any comments, asking any questions, really doing anything other than just strictly observing, then the zoning code requires that I swear you in. If you're not certain yet whether you're going to provide testimony, I can always swear you in later. But for everyone that knows that they'd like to provide something, I'm going to go ahead and collectively swear all of you in at once. So if you could all make sure that you are off mute, and everyone to raise their right hand and to answer out loud. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Great. Thanks, everyone. All right. So we're going to go ahead and get started with the owners here. Who's going to be taking the lead for us here on the presentation?
I can. True
Okay.
question.
True. The floor is yours.
We had an existing fence when we purchased the property. It was a split rail fence. It was sort of in disrepair, and we were looking at how we were going to repair it. We attempted a repair along the sidewalk to keep the dogs in from jumping and getting out of the fence to stop them from barking. We repaired the fence there, and then kind of pandemic hit, and we were thinking of different ways to just kind of brighten up the community, give some people some smiles. And we reached out to an artist out of Dayton that my wife knew. She'd done some pictures for us here in the house. We bought some of our artwork and things like that. So reached out to her to paint a mural on this fence to give it just brightness to the neighborhood, kind of add to the aesthetic. We got a lot of beautiful gardens, a lot of great landscaping throughout the neighborhood. And it would just be something to kind of, a lot of walkers coming by, something for everybody to kind of just look at and enjoy as walking through our beautiful neighborhood. So we did that. We put up the fences. Then we hired a company to come out to complete the fence all the way around. We did the work on the one side, and then we had a company come out and do the rest of the fence. We were not aware, or even though ignorance is nothing as law is concerned, but like the zoning rules, we weren't aware of corner lot rule of our property, considering our backyard to be a front yard on Woodlark from our Mayland property. So once we got a notice from the city, we kind of looked into what our options were after speaking with the zoning department. They had said that, it needed to be a 50%. They explained the zoning code, and I asked if there were any relief under the zoning code for this, or because of how the property sits so far from the corner this fence is. And when they explained the process that we're hearing today. So we went around the neighborhood. We went door to door to all our neighbors, asked them who was in support of our fence. We collected signatures, we collected letters, and we started this process. And we found out that we have an overwhelming amount of support from our communities. My neighbor's right next door to the Clauses, the Trucos, the Casey's across the street. It's everybody right by the house here who see it every day. And the people who walk by, Mr. Graham and those folks, we're all in such support and kind of in shock about the rules. So that's kind of why we're here.
Okay. So, all right. Yeah, sure. Go ahead. Yeah.
The fence that is currently up is only 4 foot high. So it's not like it's a 6 foot high fence. I don't believe that there's a huge obstruction to view. And like True said, it sits far enough back from the stop sign.
Gotcha. Okay. All right. I have some questions, but I think I'll wait and get through some more public testimony before I do that. Unless there's anything else from the owners at this time, I'll move over to the public.
You can move forward. Thanks.
Okay. Great, sure. Mr. Cahoos, I'm sorry, I'm mispronouncing your name.
Yes, yes, sir. Yes, sir.
Sure.
Lou
What would you
Coas.
like to Coas? What would you like to tell us?
Okay, well, I'd like to just look. Sorry, you minimized somewhere. I guess I shouldn't have done that. Okay, so
We can still see you and hear you.
can you hear me?
We can,
Okay,
we can hear
okay,
you and
good.
see you.
Thank you. Okay, great. So I just have some general comments. Number one, my father-in-law is the builder, and he originally owned all this property when it was just vacant land. He would be rolling over right now because he would have never gone for any of this stuff. It's not really like a fence. It's more like a billboard. They're advertising the artist's work or what. I don't know exactly what their intention is. Now, these are very nice people. I don't mean to fight with them, but I am meaning to enforce what my father-in-law actually wrote in the property deed. When my father-in-law sold the property initially, he put in the deed, which clause lives on forever, no fences. There's no fence allowed anywhere on that property.
There
And
was
so
a fence
that's
before I put it in.
So
So
hold on, Mr. Quackenbush. You'll have an opportunity to respond to all the public comment. And so if you could just hold your remarks until that time. Thanks. Just go ahead, Lou.
I believe he was making a point that it was the first sale. It doesn't matter. The clause lives on. It was up to his title searcher or whatever to find the clause. So anyway, the next thing, I think that the fence violates not only the property deed restriction, but it also violates several city ordinances, including the 50% opacity rule or ordinance, the advertising rules, ordinances, the setback rules. Now, and the artwork is facing outwardly. I don't understand if it was for the family and not for being forced upon neighbors who would want nothing to do with it. Why didn't he have it turned inwardly, the artwork? If the artwork had been turned inwardly, I probably wouldn't even be here right now. Then I want to know who's going to maintain this artwork. It already is starting to look shabby. It's faded considerably since it was initially put up. And I just don't understand is the city going to maintain this? I mean, he says it's for everyone to enjoy. So is it making it public? I just have a lot of questions about who's going to maintain this artwork. And no one was ever consulted in this neighborhood as far as I know. And while they do have allegedly 40 signatures in support of this, there are over 100 people who live in this neighborhood. And so it's not how many signatures they have, it's how many signatures they don't have. There's 60 of us obviously don't want it. We didn't sign anything. They were turned down numerous times by various neighbors. That's basically all I have to say.
Okay. Thank you for your time and your testimony. I'm going to go out of order here just briefly and ask Ms. Meehan if she could. I know that Mr. Coos had maybe some questions or some statements about the fence not complying with city regulations. And so, Ms. Meehan, I just to do some table setting here, could you clarify, did you review whether or not this fence is consistent with city regulations, in particular zoning, setback, and opacity and height and that sort of thing? And just let us know what exactly is out of compliance here with this fence and what exactly the owners are asking for.
Sure. So my understanding is that initially this came in because there was a complaint. And then the owners were cited by the Property Maintenance and Code Enforcement Division. So in a corner side yard, and basically what would be the kind of the rear yard where it's in the side yard, fences are to be no more than 4 feet tall and 50% opaque per the code. So the fence is compliant in its height, but the opacity is not compliant. The fence should be 50% open and not a solid fence at the corner. If the fence were to start at the back wall of the house, it could come straight back and then it would be considered a rear yard fence. But in this case, it comes out into the side yard. So it is a side yard fence on a corner lot. So it needs to comply with the 50% open rule. As far as the mural, we do allow people to paint murals. Typically, it would be painted like on the wall of a building, but a certificate of compliance is supposed to be obtained prior to the painting of any kind of a mural or anything like that. I can tell you we have had other people paint a mural on a fence. Typically, it is for the wall of a building, but we have had people apply for a mural to be painted on a fence. So there's also a requirement that at a corner, the fence is set back a certain distance so that it does not interfere with any kind of sight lines or anything like that at a corner. And I believe that dimension is 50 feet, which I did using Cages and the measuring tool and Cages verify that the fence does sit back more than the required amount from the corner. There's also a requirement that the fence be 10 feet back from the street. And again, doing some measuring on my own with the Cages tool, it appears that the fence starts at about 13 feet back from the street. So then it would be compliant with that site triangle requirement.
Okay. So sort of to summarize there, the only regulation that you're aware of that they are out of compliance with is the opacity of the fence.
Right. They would need to, the fence should be 50% open in a corner side yard, and they did not obtain a certificate of compliance for the painting of the mural.
Okay. And so that's something that also needs to be obtained then as well.
Right. So they would need relief also in this hearing for the mural, which if the fence were, 50% open, it's unlikely they would have a mural there. So I guess, approval of the mural would kind of go along with whether or not the opacity of the fence were to be approved.
Okay. Well, now I'm sorry, Ms. Meehan. I myself am a little lost there. You saying that I need to approve via certificate of compliance the mural that exists on the fence as a part of this hearing?
So I think that since the mural is existing, if the opacity of the fence were to be approved in this hearing, then it seems that because the mural is existing, then it would also be part of that approval because it's there. No certificate of compliance has been applied for, though.
Okay. All right. So I see it, True. Just give me 1 second. Okay. I appreciate that. Thank you. I'll admit going into this, I was not aware that any mural approval was a part of this review. And so as a result of that, I think that I'm going to keep the scope of this zoning hearing limited to whether or not 50% opacity is appropriate. And I can explain and go into some more detail about that process and the certificate of compliance in the decision, where I'll lay that out. But for now, let's move on, and I'm going to focus on whether a 100% opacity is appropriate for this particular hearing. So, True, again, I will come back to you, but I'm going to move on to Mr. Graham. Mr. Graham?
Okay.
What would you like to tell us?
Yes, so thank you. So again, my name is Brian Graham. I'm a neighbor on Woodlark, actually of both other families here today. So speaking for myself, I've enjoyed that fence ever since they started the mural. I thought it was first class the way the artist was putting the mural together. I can tell you that whenever my wife and I take our grandchildren for a walk, the grandkids generally choose to head towards the fence because they want to go down to see the bee or see the butterfly. So for us, it's been a joy to see the mural. So hasn't caused me any kind of heartburn. Again, speaking for myself. As far as some of the other arguments about whether or not a yard's allowed to have a fence or a mural, I don't know the regulations on that, but I can just say relative to the lack of opacity, not meeting the 50% opacity for a corner lot, safety is always a priority. So for a home that's on a corner, I can just say it's never caused me any issue when I've navigated the turn from Woodlark on the Mayland or Mayland on back on the Woodlark, vice versa. So in my mind, it may violate, say, the letter of the regulation, but relative to the spirit of the regulation and the safety of making that turn in the sight line, as the previous speaker just talked about, it has not caused a problem for me. So I'm in favor of the fence. I've enjoyed it, and so have my grandkids.
Okay. Thank you, Mr. Graham. Appreciate your time, your testimony here today. I'd like to offer Mr. Casey, if you're with us, if you could unmute. I know you joined us late here, so my name's David Sturkey. I'm the zoning hearing examiner. I'm presiding over the hearing. Is there testimony that you would like to add to this conversation?
I can add a small amount, but
So
frankly,
before you do that, I just need to get you checked in here. So Richard Casey is in fact your name, correct?
yes,
And are you an adjacent property owner or a property owner in the neighborhood?
I'm across the street, across the Woodlark Street from where that is.
Okay. And could you raise your right hand for me and answer this question out loud? Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Certainly, yes, sir. I do.
What would you like to tell us?
Really don't have much to say. I can understand now after listening to you pretty much what Mr. Graham indicated. I have no problem with that fence. I think that my wife has no problem with that fence. We look at it every day. And I really don't have much more to say other than I know that the almost not all of the properties, but most of the properties on these streets that were built by Mr. Mayor all have some kind of a variance on them. But you know, that's about all I can say, is that the fence is not an offensive fence to me.
Okay. Yeah, Mr. Casey, since you brought it up, are there other side or front yard fences in the neighborhood that you're aware of that have 100% opacity?
100% opacity?
The opacity that is equivalent to the opacity of the subject property fence?
I'm getting confused because I thought the argument of the zoning is that it has to have 50% opacity.
Correct. The zoning code restricts opacity to 50%. So the subject fence as it stands today is 100%. I'm asking if there are any other 100% fences in the neighborhood in the front or side yards that you're aware of.
Not that I'm aware of, no.
Okay.
I mean, I put my fence up more as a hinge, but it's farther back from the street and it's angled, so there's no opacity problem on my side of it. But that, I guess, is not my comment about the variances that have occurred. For example, Mr. Mayor, and this is to speak to Mr. Coas's comment, which I understand, and I absolutely love Mr. Mayor. He said no sheds, no parking of your trucks on the street, and those things do happen too. So I'm not sure the depth of that conformance, I guess.
Okay. Okay. Thank you, Mr. Casey, for your time, your testimony here today. Anything else you want to tell us before I move on?
No, I have nothing else. Thank you.
Okay. Thank you. All right. I'm going to move back over to Kate Meehan. She's prepared a staff report on this and I believe recommended approval of the opacity. And so, Ms. Meehan, anything you'd like to offer in addition to that?
I would just add that the applicants did submit a petition, as Mr. Coas referenced. So it does have more than 40 people's signatures stating that they are in favor of it. I also did receive some letters with the application from neighbors stating they were in favor of it. Also, the neighbor at 6231 Woodlark, who would be most impacted by this fence, that is a neighbor whose property runs alongside where this 4-foot tall, 100% opaque fence is. They also signed the petition in favor of this. So, my feeling is they are the ones most affected by this, and they don't seem to have a problem with it.
Excuse me.
So
Who did you?
Mr. Coas, I'm going to need to have you wait a second. We need Ms. Meehan to finish her comments, and I may give you an opportunity to respond, but let's hold off for now. Ms. Meehan, I'm sorry, could you continue?
Sure. So those are some of the variables that weighed into my decision making. I did also make a site visit. I did observe people walking along the fence. And I guess if they're, as Mr. Quackenbush has indicated, if there are dogs in the yard and there are a lot of people walking by on a regular basis, that I can see where their preference would be to have a 100% opaque fence at that location. But I guess that's all to say I can see, some of the reasoning behind why they want the 100% opaque fence. And again, from the feedback that I received as part of the application from neighbors, it does not seem to be something that they find offensive or have a problem with in the neighborhood.
Okay. All right, great.
Thanks,
Ms. Meehan. All right, before we go back to the owners and applicants to respond to anything you've heard, I am going to give Mr. Cahoos, if you would unmute. If you had an additional question you wanted to ask there, go ahead and let us know what that is.
I'm sorry, I'm confused about who the last speaker cited the name and the address of who petitioned for it, because she said they were right next door. If I understood the address correctly, they're way down the street.
Ms. Meehan, I believe the testimony I heard was that one of the neighbors that would be most impacted, who is adjacent.
Correct. It would be
the
property owner at 6231 Woodlark, whose property, basically the fence runs alongside a good part of their property.
Okay. Does that answer your question, Mr. Coase?
Yeah, it does. Thank you. I don't think it's accurate. 6231 is down the street, but okay.
Let's take a look. I see 6231 as being directly behind the subject property. Yeah, and I can look that up on Cages and give you an exact. Do you have the name of the homeowner, Kate?
If you give me just a moment, I can look it up.
I'll look it up. Let's see. Okay. Owner address, I just have Eric Klaus and Michelle Klaus.
Yeah, I know them.
Does that sound familiar to anyone?
Yes, I know them.
Kate, is all that information in project docs as well?
Yes, I believe that it is. Mm-hmm.
Okay, great. Okay, fantastic. I'm going to now go back over to the Quackenbushes. Now is your opportunity to respond to any of the testimony you heard or any of the questions that I've asked throughout this. So either of you can feel free to fire away.
First, appreciate everybody's time today, taking the time out of your day to be here. opposed or not. I do address the fact that, you know, this was for the community, for our neighborhood, to for just what Mr. Graham stated, to have the kids and everyone enjoy. We will be maintaining it. If you feel that it looks off, the artist will be coming back. We had planned on that coming up soon, but we're going through this right now, so I wasn't sure I was going to even have a fence. Everybody that we talk to, almost everybody, is loving this fence, especially the Clauses, the Trucos, the folks who are really, really close by, see it all the time. Overwhelming support from a lot of our neighbors. And again, I just appreciate everybody here. And I don't consider it marketing. It's just artwork, and just as much as any mural in the city. I would agree. I did not know this certification of compliance about a mural, but we would be happy to go through that process and make sure that's all compliant. We're never trying to be out of compliance. Again, we just replaced an existing fence that was there. Not
Mr. Quackenbush, if I could, sorry to interrupt. And I really want to, I think that whether the mural itself is aesthetically pleasing is extremely subjective. And so I really am trying to stay away from that and stick to the more objective opacity considerations. But you said this is for the community. Did you do any engagement with the community about what was going to go on that mural?
I say for the community.
And if it was for the community, why
we
did
it
you
for?
not do that?
You're right. We did it for ourselves. We love the artwork of this artist, right? To share something that we love with the rest of our neighbors. You are correct on that. The 50% opacity piece to it. We just, once I read the law and read the zoning requirements, we felt like we were, the safety issue was not impacted. Overall, with the variance piece, we feel like the artwork is aesthetically pleasing to the neighborhood and could increase property values, which is another piece of public interest. You know, overall artwork does tend to, especially professional artwork, does tend to do that. So strictly speaking, on the opacity piece, we look at it as we don't break any safety concerns. We are far enough back, set from the road and the sidewalk, and that would be it.
Okay. Is there, so again, outside of the mural, was there, why was there a preference for the 100% opacity instead of something that was more
we do have 3 pets, and so with the neighborhood being as used as it is, you know, to us, we feel like that could become a nuisance issue. Plus one of our dogs who is a little more sprightly, being able to see through the fence, was able to bound over the 4-foot see-through fence. He'd go for deer or for rabbits or whatever he might see on the other side. And since the new fence has been put up, he cannot no longer see through the fence. So safety and security of the pet, the family, it was chosen that we block it off so he can't see those things that he might want to try to go get to. And he has stayed in the yard pretty much since, unless the kids leave the gate open.
Okay. All right. Well, I don't think I have any more questions. Now's the opportunity. If there's anything else you want to provide in closing or otherwise before we adjourn here today.
No, I overall, the support of the community is shown in the letters and the signatures that we collected. You know, we just, again, thank everybody for their time.
Okay, great. I want to thank everyone as well for your time and your testimony here today. Appreciate having the perspective of neighboring property owners as well as the zoning department and the property owners themselves. I'd like to, there's a few issues here that, you know, honestly are a bit novel for me within the zoning hearing context. One is the certificate of compliance for the mural. I'd like to take a little bit more time to look into that. I have never, I don't know. I don't, I feel a little like a fish out of water with that, because I think that is more of a subjective determination that maybe it needs to be made by the zoning administrator. I'm just not sure. And so I need to look into that procedure a little bit more.
And Mr. Sturkey, May I add on that? So when I originally started this and I'd gotten the notice and I went down and spoke with zoning, he mentioned the certificate of compliance and said that likely what we would do is after this hearing for the opacity compliance variance, we would then take that and reapply. Because if I were to apply for the mural, I would get denied at that point in time. And so then we would go down, refill out the paperwork, submit the fee with the variance for the opacity, and then we would do the certificate of compliance for that. That's in the original sit down and talking through all of this. That's what zoning told me.
Gotcha. Okay. And I think that sounds consistent with what I would expect to be the process. And so I'm gonna of course confirm that. And you know, if there is a different procedure, I will let everyone in the hearing know that procedure is different. But I'm going to approach this particular determination, the decision I have to make, just on whether or not 50% or 100% opacity is appropriate for the fence. And I'm going to leave out, what I believe to be the subjective determination of whether or not the mural is appropriate. And so, yeah, having said all of that, there was also another legal issue that was novel to these discussions that I typically don't see, which is a deed restriction on the property. I'm not sure that that's something that's going to impact my zoning determination, but it may be something that could be pursued through a private civil matter or civil enforcement of a deed restriction. I'm not sure that I can to what amount I should or could consider that. So that's another thing that I am going to need to do a little bit of research on. Having said all of that, I will take in all that research that I do, all of the testimony here today, all the application materials and the correspondence from neighbors. I will ultimately make a decision whether or not to approve the opacity or not approve the opacity. As soon as I make the determination, I put it into a written decision. I put that into a PDF and email it to everybody who's in the hearing here today. So you all will have a copy of my decision on this particular application, really just moments after it's complete. If it is approved, the Quackenbushes can then get the official zoning permit through Kate Meehan in the zoning department. And whether it's approved or denied, there is a 30-day appeal period. And so if anyone disagrees with my decision, they can appeal it to the Zoning Board of Appeals. Let's see. Does anyone have any questions about the process at all? Okay.
No.
Okay. If you do have any questions about the process between now and when the decision is issued, or even after the decision is issued, I'm happy to answer those questions. If you want a status update on where I'm at with the decision, I'm also happy to provide that to anyone. If you just want to email me directly, I'm happy to do that. What I can't do now that the hearing is closed is take in any new evidence. So new arguments, new pictures, new documents, none of that can be considered now. The hearing and the evidential window is now closed. I need to make a decision based on everything that's currently in the record, and so I will do that. I think that's it. Again, if you have any questions, please feel free to reach out to me directly. I want to thank everyone again for their time and their testimony. Hope you all have a wonderful day. We are adjourned.
Thank you.
Bye.